having been from the e-discovery world many, many years ago, I think what strikes me now about artificial intelligence, and when you try to adopt it in a company, is that we kind of presume that companies know where their data is and what kind of data they have. And that's something we still haven't, finished or solved from the e-discovery days.
Because when you start thinking about AI, right? AI itself, it's not new. It's dates back to the 1950s and maybe earlier. And AI by itself is just a technique that enables computers to mimic human intelligence and perform human-like tasks. But why are we talking about AI today?
So now that we've identified two primary sources of contract or principles of contracts that govern the use of AI, our terms of use, and our traditional negotiated contracts between the AI service provider and the user, what are some of the things from an IP perspective that we should be on the lookout for?
Bit of an issue in this industry, by which I mean that this is the new hot thing. It was, NFTs before that, it was blockchain before that, VR, AR, Web3, whatever. Name your sort of hot topic button of the day. And you've got a lot of folks who are trying to get territory, by which I mean patents, competitive advantage, whatever.
Generative AI, whether it's ChatGPT or something that's creating art or graphic design or something of that sort, or just operating a self-driving vehicle, or could be any number of different applications. And as part of the diligence process and evaluating and looking at how a company is using AI,
when doing a deal, it's also important to check the underlying software to make sure that it's clear for use. A lot of companies build upon existing software, and there's very specific licenses that are granted in connection to the software. So double checking that the underlying software is also clear and okay for use before the acquisition is another.
Some commentary, and I think Gail was right here, that it's much better to go later because you get to feed off what other people have said. And it's been a fascinating conversation because different speakers have talked about different companies in different states, and what they're doing, and different buckets of data and what they're doing with that. Is it data going in? Is it data going out? Is it the algorithm itself? Is it protections of all of that, to kind of rig the data a little bit to protect it in some way?
And all three kind of considerations come into mind, which is, what are we thinking about when clients are licensing material that we know is copyrighted, we know is protected, and we want to keep it that way, whether that's through a licensing agreement or just through terms and conditions, if that material is being able to be downloaded or available on their websites. So as Kaylee pointed out, the case law right now is not clear as to what would constitute infringement.